go on the record in the matter 25 CM 171, State of Wisconsin versus Josh Doriat. The state appears through District Attorney Kevin Schmidt in person. Mr. Doriat appears in person with his counsel, Joel Feliski, who is not his counsel, but Amber Sherwood is his counsel, but he's making a special appearance due to a personal issue with Ms. Sherwood. We're set today in this matter for a plea and sentencing. We were here yesterday in which the court was informed that there is.
This case starts off quietly, but don't let that fool you. A man facing criminal trespass charges, a last-minute attorney substitution, and a deal already on the table before the hearing even begins. But here's where it gets interesting. Instead of jail time, the court is considering a deferred judgment, a second chance that could wipe everything clean. The real question is, has he truly earned it, or is this a risky gamble by the court?
They are in the file, but they have been submitted.
I just saw them. They're document 32 and 33. Thank you so much. And Mr. Doriat, did Mr. Feliski fully and thoroughly go over this with you?
Yes, he did.
Oh, you just turned it on.
Turned it on. It's okay.
These ones you don't have to hit and touch and do those things.
Okay.
He did, and so he reviewed the plea questionnaire waiver of rights form as well as the deferred judgment of conviction document.
Yep.
Did he essentially read them to you word for word?
Yes, he did.
And you understood everything completely?
Yes, I did.
Did you sign those documents?
Yes.
So you're pleading guilty to that sole count of criminal trespass to a dwelling?
Yes.
And you're 33 years old, 12 years of schooling. You can read, write, you understand the English language. No alcohol, drugs, or medications, correct?
No, I haven't had any alcohol, drugs, or medication.
You're what?
I haven't had any alcohol, drugs, or medication.
Oh, good,
Yeah.
excellent. All right, so your attorney or Mr. Feliski went over your constitutional rights with you, is that correct?
Yes, he did.
And do you understand them completely?
Yes, I do.
Do you need me to go over those rights with you in any more detail?
No, I don't.
And do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, I do.
Do you understand that the state would have to prove on or around September 11th, 2025 in Burnett County, Wisconsin, you intentionally entered and remained in the dwelling of DD without the consent of the owner of the property? That includes the dwelling, as no person was lawfully upon that premises. And so you intended to breach the peace. Do you understand what that means?
Yes, I do.
Okay, so that's what the state would have to prove. Do you understand that the maximum possible penalty could be a fine of up to $10,000 or up to 9 months of incarceration or both? Do you understand that?
Yes, I do.
And do you understand that there is an agreement here for the court to accept that deferred judgment of conviction document, which has certain conditions?
Let's break this down because this is crucial. A deferred judgment of conviction isn't just a light sentence, it's a legal opportunity to avoid a permanent criminal record entirely. If the defendant follows every condition for 12 months, no crimes, no contact with the victim, and full compliance, the conviction can be dismissed. But if he slips up even once, the court can immediately enter a conviction. So ask yourself, is this accountability or a second chance that not everyone gets?
$60 within 60 days. However, I know the situation with you and this incident and all of that happened. And I don't recall if you were homeless or at least at this time, but I know that you are having financial issues and problems. Is that correct?
Yes, I was.
And so I don't know if you still are or no.
No, I'm not.
So did you find a job?
Yep.
Oh, good. Where are you working?
Taco Bell.
Excellent.
Yeah.
And so you found a place to live?
Yes, I did.
That's good. I'm very glad to hear that. But you do have $250 posted as bail. Generally, the court holds all of that until this 12 months is up. But what I'm going to do is I'm going to tell you right now, I'm accepting the deferred judgment. I'm just going to do that. But I'm going to send $150 to the district attorney. I'm directing the clerk to do that, to cover that, to have that off of your back. Okay.
Okay. Thank you.
And so then we'll just have $100 just sitting here until the end of this agreement. And if everything goes well and it gets vacated, then you'll get that money back. Okay.
Okay.
That $100. Okay. So you understand all that you must do and comply with?
Yes.
But do you understand? I don't have to I don't have to accept this if I don't think it's appropriate. You understand that?
Yes, I do.
Did you go over the criminal complaint with your attorney and the facts that are alleged there about what happened that day and why you were charged with the crime?
Yes, I did.
For the most part, are those facts accurate?
Yes.
Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to this charge?
No.
You're doing so freely, intelligently, and voluntarily.
Yes.
And you're satisfied with your attorney services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
Then as to the sole count, criminal trespass to a dwelling, how do you wish to plead?
I'm guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty. I'm going to hear arguments as to the deferred, Mr. Schmidt, and we are in victims' rights compliance.
We are. I'd ask the court to accept the deferred judgment. I think the victim really is in support of this. When we are crafting the sentence in this case, the victim liked the idea of a deferred judgment because it keeps the no contact going for the duration of it. That was the main thing they were going for. So I think it accomplishes that given these facts and given what was said at the previous hearing yesterday. I think the court should adopt it. Thank you.
Thank you. Mr. Felisky.
Thank you, Your Honor. I would first note on the issue of credit, Mr. Doriat was brought into custody when this incident occurred on September 11th of 2025. His bond was then modified and he was released on September 19th of 2025. By my math, he would have 9 days of credit. Your Honor, I think this is an appropriate agreement. I think that it properly balances out both the stick aspect, so to speak, in terms of an incentive for Mr. Doriat to follow the agreement. I think he certainly doesn't want a criminal conviction on his record. I think he certainly would like to avoid any of the consequences that would come from that conviction. In addition, Your Honor, I believe this agreement addresses the carrot aspect of that dynamic. If Mr. Doriat is able to successfully complete this agreement, and I have no doubt that he would be able to based on my interactions with him, he will not have to have this on his record. So this agreement really gives him a chance to prove that he can take care of this matter on his own, address whatever the underlying issue is here. As was noted on the record, Your Honor, Mr. Doriat, since this matter occurred, has been employed. He's found new residence. So I think he's already demonstrated that he's taking the initiative here. He's ready to put this behind him, take responsibility, and be a law-abiding member of this community. Overall, I think this is an appropriate agreement. I would ask the court to follow it. Thank you.
Thank you. Mr. Doriat,
Yeah.
anything you want to tell me, you want to say?
No.
Okay. I think this agreement is appropriate. This is a family issue, family matter. And I believe at the time you were homeless or you didn't have a place to stay or yes, and you're nodding your head. Yes, that is true. And so that's what I recall why you had stated you had went there. You needed a place to stay. You're doing.
This is where the human side of the justice system really shows. The judge isn't just looking at the crime, she's looking at the context. Homelessness, financial struggles, and now a steady job and housing. That shift matters. Courts often weigh rehabilitation over punishment in cases like this. But here's the tension. Should personal hardship reduce legal consequences, or does that create unequal justice? Drop your thoughts because this is where opinions usually split.
All right, cool.
Okay. All right. So I believe that's all I need to do. Thank you. We are adjourned.
Oh, I was on too. Is it Apple? Quite sure on Androids, so sorry.
Mr. Chapman, I forgot to ask you yesterday, and you're probably not going to know it off the top of your head, but you have a client, Thomas Toll.
Toll, yes.
Toll. and it's set for plea and sentencing in June, I believe. And I was told that he's not making his court-appointed payments, so you can just talk.
I can
I don't
reach
know
out to him.
I don't know if it matters, because quite honestly, your bills are usually very good. And you put down the deposit, but.
How
just
much
a
was his
reminder.
deposit?
What?
How much was his deposit?
500.
Probably going to be pretty close. I don't think there's been anything significant in his case that sucked up a lot of time.
But he's gonna need to pay court costs and things and whatnot, but just, oh, but that's an OWI third, but I don't know, just a reminder.
I will give him a call.
Alrighty, are we ready? In 25 CF 106, State of Wisconsin versus Jacqueline Anderson. The state appears through District Attorney Kevin Schmidt in person. We have Daniel Chapman, Defense Counsel in person, as is Ms. Anderson. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Chapman, can you please recite it for the record?
Your Honor, Ms. Anderson will be pleading to the possession of methamphetamine charge, and there will be a joint recommendation for a withheld sentence, 1 year probation. The drug paraphernalia charge will be dismissed and read in.
All right. That's the agreement that you've reached, Ms. Anderson?
What's that?
That's the agreement that you've reached?
Yes,
All right, I have in front of me the plea questionnaire waiver of rights form. Did your attorney go over this document with you?
yes,
Do you understand it completely?
yes,
And did you sign this document?
yes,
It says you're pleading guilty to 1 count of possession of methamphetamine. You're 56 years old with 11 years of schooling. You can read,
59,
excuse me?
59.
Oh, you're
Did I
59.
write 56?
You wrote 56.
Sorry.
May I change it to 59?
Yes.
All right, so 59, 11 years of schooling. You can read, write, you understand the English language. No drugs, alcohol, or other medications in the last 24 hours. Is that all correct?
Correct.
Your attorney went over your constitutional rights with you, is that correct?
Yes,
And they're listed on the first page of this plea questionnaire. Do you understand them completely?
yes,
Do you need me to go over them with you in any more detail?
I don't think so.
Okay. And so you understand that by pleading guilty, you're waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
You understand that the state would have to prove on or around July 11th, 2025, that you possessed the substance was a controlled substance, methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the
Yes.
state would have to prove? Do
yes,
you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both?
yes,
You understand that there's an agreement for 1 year of probation, but I don't have to follow that? You understand that?
yes,
I could sentence you to any sentence that I feel is appropriate, which could be the maximum penalty if I deem it necessary. Do you understand that?
yes.
Do you still wish to proceed and enter a guilty plea?
What was that?
Do you want to enter a guilty plea
Yes, please.
still? Did your attorney go over the criminal complaint with you? And that's that original charging document where it basically says what happened and why you were charged that day?
Yes,
For the most part, are those facts accurate?
yes,
Are you pleading guilty to possession of methamphetamine because you're guilty of possessing methamphetamine?
yes,
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
I think so.
And so he's talked to you about any, whether or not he thinks that there are any defenses or a lack of defenses in this case?
No.
Yeah, well, did he go over, if you go to trial, then we can prove this, or we can say this?
Oh,
Did he do those kinds of things?
yes,
Are you satisfied with his services?
yes,
Do you have any questions for the court or for your attorney before I proceed?
no,
All right, then as to Count one, possession of methamphetamine. How do you wish to plead?
Guilty.
The court, oh, do you understand you're pleading to a felony? You would no longer be able to use or possess a firearm for life.
Yes.
No voting in any election until your civil rights are restored.
Yes.
And now you wish to plead guilty, is that correct?
Yes.
The court will find that your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty. Count one, count two will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
I think the court should follow the joint agreement as listed in the questionnaire. This is a person who is today 59 years old and she has no prior convictions. So even the conviction on its own is already going to be a significant consequence to here. This case involved another person named Orville Simon who passed away subsequently after this. I think she has good knowledge of how dangerous controlled substances can be. I think that for a first-time offense ever, this is an appropriate disposition. So I'd ask the court to follow it. Thank you.
All right, Mr. Chapman.
I believe she actually has 2 prior DWIs, but it is her first felony conviction. And she did do an alcohol and drug assessment. Strangely enough, Miss Anderson told the alcohol and drug assessor that she has not used methamphetamine since she was in her mid-20s. Might be true. Assessor seems to think there may be some denial going on there. Either way, I believe it's an issue that probation can address. But yes, for a first-time offense, for a simple possession of drugs, I agree this is appropriate. And I would point out that if it wasn't for her cooperation with the police, she probably would have walked away from this. She gave consent to search. She gave consent to enter the garage. They weren't even there looking for her. She was just the person who was in the home and sure, you can search me, and they found the meth.
Okay. Ms. Anderson, anything you need to know? You need probation?
What's that?
You need probation? What do you think?
I don't think so, but I wouldn't deny taking it.
No,
What-
I know, and you're sitting there, and I can tell that this isn't a great experience for you. I know that, and
I've had a hard life.
and tell me about it.
My kids,
What's going on with your kids?
I'm being tortured.
She's been the victim of some
Person is
domestic
Jason
issues.
Tashney.
All right, so I understand. All right, the great thing about my job and the bad thing about my job is I remember a lot of things, and I have a lot of things up here, and I can connect the things. I understand. So you told the AODA assessor or counselor that you have not used methamphetamine, but you're pleading guilty to methamphetamine. It's possession, and you know, your attorney, and you're nodding your head, yes, your attorney went over all of what
Yeah.
it means to be in possession and to be charged with the crime. So you understand that, right?
Yes,
And so that's why you're pleading guilty, right?
yes.
Okay, now, be honest with me and tell me what issues you have.
I give somebody's got my house bugged. I'm not allowed to own a phone without somebody tapping into it.
Okay. So there are some things that it sounds like perhaps maybe some counseling. Is that something that could help?
Yeah,
Maybe something like that.
I do have a hard time talking to people.
Okay, but maybe I know talking to an attorney is not easy sometimes, but you were able to tell Mr. Chapman what was going on and what you're thinking and feeling, right? And that's a yes. And so
Yes.
you think you can open up to a counselor
Yeah,
and that could help?
I think so.
Okay, because
What would help is somebody, whoever, leave me alone.
Yeah. I understand that. So it's sounding like I was leaning towards not having probation. But it sounds like maybe the services and maybe having an agent talk to you and help connect you with people that may be able to help you is a good thing,
I
right?
tried reporting it.
And so again, you may not have AODA issues. That might not be what we're looking at, but maybe there's some mental health here where you can go to a counselor and you can talk about all that's going on with you, and work through that. And then a probation agent can help set you up if there are other things that they can concentrate on and look at that can assist you in your life. Okay. So here, knowing all the facts now, and this is why I like to know all the facts and the totality of the whole situation. So I do think that this agreement is appropriate. Okay. And so I will follow it, and I'll do 1 year of probation. I'm doing an imposed and stayed. This will never in my life be a prison sentence. Okay. And this isn't even a very lengthy jail sentence. So did she sit any time in jail?
One moment, Your Honor.
2 weeks.
July 11th.
I think it was about 2 weeks.
Okay, it's gonna get me the exact date so that I can put that on the record.
Cash bond was required. Looks like it was posted on July 23rd, so the 11th until the 23rd should be 13 days.
13 days of jail credit. Okay. So here's what I'm gonna do. I am going to do 1 month imposed and stayed. All right, so if you're revoked, you have a month imposed and stayed. On probation for a year, they can help you out, do some things. Absolute sobriety, no alcohol, no illegal substances. I am going to order a mental health evaluation. That's going to the therapist, talking about the things that are going on, and they can help direct and find some things and services to help you, okay? Because it sounds like you have some issues, personal things that are going on that you need help sorting out and figuring out, because it looks like it's overwhelming you a little bit and that it's very heavy on your shoulders. And you're shaking your head up and down saying that that is all correct, right?
Yes.
Okay. And so the mental health evaluation, and perhaps, I don't know if a psychiatrist is needed, because you take all medications as prescribed, because maybe there is something that can help with your anxiety, help to settle things down a little bit, okay?
I can't even get to the doctor.
You don't have transportation? I'm also gonna order that through probation, they talk to, I think, ADRC or something of that nature, because they can help assist with transportation for medical, for groceries and those kinds of things. I believe, I'm not certain, but that's something that I think that they can help with, or they can direct you to other services, and a probation agent can help with those things as well, setting those things up. So those are the things that I am going to order. And I wrote it down. How many days did you say, Mr.?
13.
13 days of jail credit if you are revoked. You have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. I'm only going to assess the DNA surcharge of $250 here. I'm waiving the court costs and fees. I think you're going through a lot right now, and to put on a financial burden may be too much. So we have the $250. Oh, and you pay Mr. This is a court-appointed case. He's really good at billing, so I don't believe it'll be too substantial, but you'll just have to continue to make your monthly payments until that is paid off, okay? But otherwise, I'm waiving the court costs and fees. I do need to order your DNA. You need to go to the jail as soon as we're done here today, provide your DNA. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to me. It's easy to do. You can Google it or ask Mr. Chapman if that's what you wish to do.
To do what?
request that your DNA be expunged. Have you ever heard of CODIS, the CODIS system, where they have all the DNA and all the nation and all those things?
Yeah.
With crimes, they take your DNA, but you have the ability to request, hey, I want that expunged. I don't want that in the system based upon this crime. The Department of Justice, the Wisconsin Department of Justice gets to decide that, not me. Okay.
Okay.
All right. So you can do that. Firearms, no possession of firearms for life, no voting in any election until your civil rights are restored. If you fail to pay your fines, fees, or attorney's fees, a civil judgment will be entered against you, and you could sit up to 6 months in jail and have a warrant. Okay, so it's very important you pay your fines and fees. Mr. Schmidt, what am I missing?
Nothing, nothing from me.
Mr. Chapman.
Nothing else, Judge.
All right, thank you. We are adjourned. Oh, this is an Amy case.
We have more after this.
An Amy and a Mr. Benson. You can take this too, so you can just have it. It's not for this case. We will go on the record in the matters 25 TR 662, 25 TR 668, 25 TR 984, Village of Siren versus Crystal Gorman. Appearances are, we have the Village of Siren counsel Adam Benson in person, we have defense counsel Bruce Anderson in person, and we have Ms. Gorman. We're set today in this matter for a refusal hearing. Are we ready to begin?
Your Honor, unfortunately, no. When I recently called the Siren Police Department this morning, they said they had this scheduled as a status conference, which was 2 weeks ago, of course, I believe. And my officer is on vacation till tomorrow afternoon. I would not be prepared to go today, and I would simply ask for a continuance. Don't know if I'll get it, though.
Mr. Anderson.
Your Honor, this is the date and time set for the refusal hearing. Certainly nothing gets an officer's attention more than dismissal, finding that the refusal was reasonable because they're not prepared to go forward. So I would ask that the matter be dismissed or found reasonable or not proven as unreasonable, whatever the court's most comfortable with.
The notice was
Oh, I'm
sent-
sorry. I just
Go
one more
ahead.
comment. Nothing gets an officer's attention about the importance of scheduling more
So
than
here's the final outcome. The court accepts the deferred judgment,
having
giving the
a portion
defendant
of
12
his
months
case,
to prove he can stay
dismissed.
on the right path. No conviction for now. If he complies, this
This was
case
set
disappears from his
on
record.
March 13th,
If not, it
2026.
comes back with full force.
At the
It's a
final
classic example
pretrial,
of the
because
justice
this is
system
a
balancing
step that needs
punishment
to
with
occur
rehabilitation,
prior to
offering a
a
path
trial
forward instead
occurring.
of a
This is an
permanent one.
OWI
And then we
first
shift into a
refusal.
second case, where
The
things take a
notice
very
in
different turn:
the
mental
court
health
that the
concerns,
court
probation
sent
debates, and a much heavier
clearly
courtroom
indicates
dynamic.
that this is
If you
a
found this case
refusal
as shocking
hearing.
as we did,
It was
make sure to
statuses
hit that like
tracking
button,
on
share your thoughts in the
the
comments, and
OWI
don't forget to subscribe
first,
for more
as
jaw-dropping
well
courtroom
as the
breakdowns.
operating with a PAC first. The other matter, the refuse to take tests for intoxication after arrest, that was set for a refusal hearing today because again, it is a required prior to the trial, and the trial is currently set for April 14th at 8:30 in the morning. Mr. Benson, I'm hearing that you spoke with the officer, that he knew that it was set for this day, but then there
And
was
Your Honor,
no-
I'm not trying to throw my officer under the
No,
bus,
I know
but
that.
after our last hearing, I immediately emailed the Siren Police Department and said we're scheduled for a refusal hearing today. So
I'm confident that you did so. And do you have any rebuttal as it relates to dismissal? And are you asking dismissal of the entirety or simply the refusal?
Oh, I'd love to have the entirety dismissed, but I don't think I could ask for that today.
I really can't argue against it. This is the date and time. I'd like it to be continued. I don't know when we would have time again, based on your calendar, Your Honor.
Do not have time to have a refusal hearing, and I don't know where that's gonna lead the OWI set for a trial. Trying to pull up my calendar, and my calendar to fit with your calendar, Mr. Benson, to fit with Mr. Anderson's calendar, even if the court were to have leniency with regards to this, honestly, I would only be able to, when is this scheduled? This 14th?
14th, Your Honor.
I would only be able to fit it in on Thursday in the morning. However, I trust that you informed the officer and that this matter was set because it needed to be set prior to trial. And Mr. Anderson makes a very solid point that we should have the officers here. It's just like a preliminary hearing. And if we don't have them here, then we can't move forward. They have the right to request this be dismissed. And the court takes that into consideration. Based upon that, the court is going to dismiss 25 TR 662. So we are ready to go with the other two matters on April 14th, correct?
Yes, Your Honor.
Well, certainly, Judge, this does change my intended trial. I can certainly make it. I assume you were the one and only trial for that day?
That's it. You're my one and only.
Well, okay,
I'll
that'll
just-
work. I'll have to make it work. I wouldn't.
We have our analyst lined up for that day as well. So
Pardon?
What?
I said the analyst is
Oh,
coming
yeah,
that
and
day.
we
So
have the analyst. Just wait 1 second. I wanted to look at something. We have the analyst. I'm getting confused, quite honestly, because you have a few OWI. That's okay, tomorrow. All right. No, I think we're good. Okay, so we'll see you on the 14th. We are ready to go.
Thank you.
Thank you.